Former President Jacob Zuma failed to secure the recusal of 6 justices from the adjudication of the IEC's appeal against the Electoral Court order, which allowed him to remain on the MK party candidate list. As a result, the IEC proceeded with its appeal against the Electoral Court order, submitting that the court fundamentally erred when it found that a remission of sentence reduced Zuma's sentence from 15 months to 3 months, and emphasized the need for finality on this matter prior to any votes being cast.
Whether he is entitled to contest cannot be established after he has contested. That would be absurd. Finality on the question, therefore, of eligibility must be reached before the 29th of May, not after the 29th of May. The question is, should he be a candidate or not? And the public is entitled to know the answer before it votes. It cannot vote first and find out later that he should not have been a candidate. Secondly, there is a need to safeguard the integrity of the election. If a leader of a contesting political party is allowed to contest while the Constitution disqualifies him, as the second respondent wants to do, because that's what Mr. Zuma wants to do, that will undoubtedly poison the election and produce a disputed outcome.
Friends of the Court, CASAC, Corruption Watch and the Ahmed Kathrada Foundation echoed similar sentiments before the Apex Court, highlighting that the section must be read through its purpose to safeguard the National Assembly from those who are unfit to serve in it, and a remission cannot subvert this.
We submit that a remission of sentence is quite different. It does not have the effect of expunging the legal consequences of the conviction and sentence. It is only about the practical question of how much time must this convicted and sentenced person remain in prison in service of that sentence.
The MK party and former President Jacob Zuma opposed the IEC's application, arguing that the question of eligibility lays with the National Assembly, and the IEC had no power to disqualify Zuma. Justice Taron earlier probed counsel for the IEC in the contextual interpretation of Section 47, subsection 1E, highlighting the fact that the drafters were aware of the right of appeal. An argument the MK and Zuma aligned itself with, as the former president's conviction and sentence was not appealable, as it was handed down by the highest court in the land.
Justice Taron is perfectly correct. We have to assume that the drafters of the Constitution knew, when they used the word convicted, they didn't just invent it in Section 47. That word is used in Section 35 for the first time. Convicted. There is a presumption of interpretation that a word used in the same constitution or in the same statute has the same meaning. So that's why they didn't say all these things that are now being smuggled in. Well, if the appeal is available and so on. No. They say if you're convicted or sentenced. If you want to know what convicted means, go to Section 35. And Section 35 makes it perfectly clear under what circumstances a person may be convicted or sentenced for that matter. And those circumstances are that you would have enjoyed all your rights in Section 35.
Judgment was reserved in the matter. Kani Mapanga, SABC News, Johannesburg.